Ready to strengthen your reading comprehension? Take a listen.
Hey everyone, and welcome to This Explainer. Today, we're diving deep into the actual on-the-ground realities of Maryland real estate law. Have you ever wondered what really happens behind closed doors when a property changes hands? Or maybe when it's suddenly threatened by a bank? Well, we're going to open up the property playbook today. We're separating the common myths from the hard, undeniable legal realities of probate, property transfers, and even some pretty unconventional legal defenses. Whether you're trying to figure out an inherited family home or you're seriously looking into asset protection, this explainer is built to empower you with direct, actionable knowledge. So let's get into it.
Here's a quick roadmap of what we're covering. First, the quick quitclaim myth. Second, Maryland's automatic probate rule. Third, the right way to inherit. And finally, number 4, fighting foreclosure with PMAs.
Okay, let's jump right into Section 1, the quick quitclaim myth.
Okay, let's dive into this. Picture this scenario. You know how it goes. When a family member passes away, dealing with courts, lawyers, and all that legal red tape is literally the absolute last thing anyone wants to do, right? The temptation to just sign a quick piece of paper and bypass the entire system is incredibly strong. So you might be wondering, can you just quitclaim grandma's house directly to yourself? Let's say she passed away, everyone in the family is totally on board and agrees the house is yours, and you just want to draw up a simple quitclaim deed to transfer the title into your name. I mean, it sounds super simple, perfectly logical, and highly efficient.
Well, here's the hard truth. No, not without probate. You absolutely cannot do this. And honestly, if you try to take this shortcut, the 1982 Maryland Supreme Court case in re Estate of Simon would very much like to have a word with you. Under Maryland law, an individual simply cannot directly quitclaim a deceased relative's property to themselves. You have to follow proper procedures. There are absolutely no fast passes in the Maryland property playbook. Which brings us to Section 2, Maryland's automatic probate rule. Think of this as the strict referee of our explainer. So this is the legal mechanism that immediately locks down an estate the literal second someone passes away. Maryland Estates and Trust Code Section 1301 says, and I quote, "All property of a decedent shall be subject to the estates of decedent's law, and upon the person's death shall pass directly to the person representative." Basically, the state automatically steps in as the ultimate gatekeeper. The property does not pass directly to the heirs. It doesn't matter what the will says in that exact moment, and it doesn't matter what the family shook hands on. The state essentially freezes the board. And that brings us to the personal representative. As case law like Solis versus Schuneman established, this legally appointed individual is the only person holding the state-issued key to the property. They hold the legal title temporarily, just for the administration and distribution of the assets. And you cannot just call yourself the personal representative, you have to be formally appointed through administrative or judicial probate proceedings. Now, here is exactly why this matters for you. Bypassing these legal requirements renders the transfer completely invalid. If you unilaterally try to quitclaim that property to yourself without being officially appointed as the personal representative, well, actually, scratch that. It's not just a simple paperwork error. It legally voids the entire transfer. It's as if it never even happened in the eyes of the law. You've just wasted your time, your money, and potentially created a huge mess by clouding the property's title. Okay, Section 3, the right way to inherit. Time to navigate this maze properly. So the crucial point is, how do we pivot from playing defense to actually playing offense? How do you get that title legally in your name? Well, Maryland law boils down to an easy, actionable 3-step checklist. Step 1, open probate. You have to formally initiate the process with the court. Step 2, get appointed as the personal representative, or PR. The court has to officially stamp and grant you that authority. And Step 3, execute the PR deed. Notice I didn't say quitclaim deed. You, acting in your official, state-sanctioned capacity as the PR, execute a very specific document to transfer the property to yourself as the heir. That personal representative deed is our ultimate goal in the inheritance process. It's like the missing piece of the puzzle, the crucial link in the title chain. It proves to the world, to future buyers, and to title companies that the transfer fully complied with state oversight, followed the will or intestacy laws, and is 100% legally valid. This right here is exactly how you win this part of the property playbook. Let's move on to Section 4, fighting foreclosure with PMAs. We're shifting gears into a totally different high-stakes scenario now. We've talked about getting property, but what about protecting it? Let's look at how we can use the law defensively to shield property from foreclosure using something called a private membership association, or PMA. A PMA is an unincorporated association recognized by Maryland law as a distinct legal entity. totally separate from its members. And this is grounded in Maryland Courts and Judicial Proceedings Code, Section 11-105. What this means in plain English is that a PMA can sue, be sued, and, crucially, own property in its own name. It is a completely separate legal person from you. And this brilliantly illustrates how you can build a massive defensive structure. The comparison here is just stark. Under individual ownership, if a foreclosure happens, your personal assets, your credit, everything is directly on the line. You're the target. But under PMA ownership, the property is held by a shielded, distinct legal entity. So if a foreclosure action kicks off, it targets the PMA, not you personally.
You might be asking, just how deep does that shield actually go? Take the 2013 Maryland appellate case, Penske versus Pikesville Recreation Council. That case demonstrated that members who aren't involved in decision-making or who didn't explicitly authorize the mortgage terms are generally not personally liable for the association's obligations. The judgment can only be enforced against the association's assets. It essentially creates a legal fortress around everyday members. So how does this play out in a real-world foreclosure fight? Maryland Real Property Code Section 7-105.1 lays out a very strict statutory timeline. First, the bank has to issue a notice of intent 45 days prior. Then, the actual filing occurs. And this is exactly where the PMA steps onto the battlefield. Because the PMA is the legal owner, it can step right in and demand mandatory loss mitigation. They can challenge procedural requirements and basically force the massive bank to fight a distinct legal entity that has its own set of rights.
And let me tell you, a PMA can bring some serious heavy artillery to that fight. You see, Maryland foreclosure is an equitable process, which means fairness legally matters. A PMA can fire off equitable defenses like lack of default, fraud, non-compliance with statutory requirements, and failure to mitigate loss. Case law like Wells Fargo versus Neal proves that if a bank fails to adhere to those mandatory loss mitigation regulations, a PMA can argue the foreclosure is inequitable and potentially seek an injunction to stop the whole thing dead in its tracks.
But hey, before you go thinking this is some kind of legal magic wand, remember this absolutely crucial point. The PMA shield requires flawless documentation and strict compliance with mortgage contracts. You can't just slap the letters PMA on a piece of notebook paper and ignore your mortgage payments. No way. The ownership transfer has to be documented perfectly, and the PMA itself has to adhere to all contractual and procedural rules. If the PMA doesn't act perfectly within those legal boundaries, the whole shield falls apart.
We have covered a ton of ground today in this explainer, from the absolute necessity of state-appointed personal representatives to the incredibly complex defensive fortress of a private membership association. I want to leave you with this final thought. If the law automatically steps in the moment property is passed down, is your property truly protected while you are still holding the keys? Understanding all these rules isn't just about fighting legal battles in court, it's about setting up your playbook correctly before the whistle even blows. I highly encourage you to keep exploring, keep learning, and dive even deeper into the fascinating world of property law. Thanks so much for joining me on this explainer, and I'll catch you next time.